Welcome to Lunch at Circle TV. I'm Per Carlson. I'm here today at Restaurant Massio in Paris with Tom Thorelli. Tom, you are actually a lawyer, but you're here to talk about business issues. Now, in what way is it that a lawyer can help building businesses on new markets?
Well, the first thing is to help sensitize clients to the realities of doing business in different countries. Some countries one can do business with similarly to the way one does business at home. In other markets, it's very important to get a good idea of what the legal structure is before doing business there, so as to minimize the risk of legal problems when one does business.
And you're working specifically in the US or a little bit all over the world?
Well, our clients are a little bit all over the world, particularly in Europe, but we are an American law firm. We're 5 lawyers located in Chicago, whereas I'm currently living here in Paris. As to give you an idea, there are about 55,000 lawyers in all of France. In Chicago alone, there are 40,000 lawyers. So one can start to get an idea as to how lawyers are used in a very different way in the United States from the way they're used anywhere else in the world. And that's in a preventive capacity. Yeah. We talk to lawyers before we do business. In France particularly, there's no point in talking to a lawyer until there's a problem. In the US, we know once there are problems, the lawyers are the only ones that are going to make the money.
So you have, in Chicago, you have about as many lawyers as we have in all of France, almost.
Yes.
Yeah. But can you give me some examples of what are the issues, what are the difficulties that you can get into if you don't talk to someone, if a business person doesn't talk to someone like yourself?
Well, the first thing is to recognize that whoever you're talking with in the United States about doing business with, they have a lawyer. That's why there's so many lawyers in the United States. And they're calling their lawyer all the time, especially when they're going to do business internationally with a French company, for example. They're going to want to know, how do I position myself in order to maximize my protection, but also to acquire legal rights. And most foreign companies don't think much in terms of legal rights when they're doing business internationally. But these legal rights relate to intellectual property. Right. That's the first area that we most often work with our clients on, because most of our clients being small and medium-sized, they need to be able to distinguish themselves quickly and easily from their competitors in the United States, and usually that's with technology. Then you better protect that technology as you enter the U.S. market with sometimes patent work, but lots of times confidentiality and non-use agreements à l'américaine, not a French one-page document, but something that actually has more teeth to it in the United States that ends up being 3-4 pages long. One of the reasons why agreements in the United States are so much longer is that there is no code civil. And as a result, everything comes based on case law.
So you can't really go and look it up in the law book and see what does the law say. You have to talk to a lawyer and say, what's the history?
Yes, because if you don't get on paper the relationship that you want to have with your partner in the United States, it's going to be their word and your word. Frequently, our clients come to us having already started doing business with partners in the United States, but never having had a written agreement. And part of the reason why they haven't had a written agreement is they want to save the $2,000 or $3,000 expense in getting a good contract in place. But another reason is because they want to retain some form of flexibility in the relationship. The problem is that, of course, if you're doing business with somebody, there's an agreement, but it's an oral agreement, and you have your interpretation, and your American partner has their interpretation, and they may be very, very different. And it's
so what can happen if you don't take care, if you don't write things down? What kind of trouble do you get into?
Well, first of all, you can lose your intellectual property rights through disclosing information that might be
like programs and
sure.
other. We're talking
software.
about very much technology
Yes.
sector here, so it's the internet platforms or software and things like that that
Absolutely.
then fall into the hands of the U.S. partner.
Yes,
Or
exactly.
foreign partner, if you know.
Absolutely. Another one is, of course, that frequently the foreign company allows the American potential partner to prepare a written contract. Again, trying to save money, or because they haven't thought of it, or they don't have a lawyer in the United States. And because Americans are sophisticated about legal issues, they will prepare contracts that protect their interests. And frequently enough,
Natural, yes.
yes, of course, of course. And as a result, often enough, these contracts are extremely one-sided, and companies end up losing their intellectual property rights, and not only losing their market in the United States, but almost creating a competitor for doing business internationally.
So now you work with your clients, those people that you help bring to the U.S. market or other foreign markets, and your clients are both French and from other countries in Europe. We're in France today. Do you see any difference in how your clients reason difference between French clients or Scandinavian clients or UK clients, or are they all the same?
Well, first of all, being in business myself, obviously with my own law firm, the French clients, they pay their bills. That cannot always be said across the board with everybody else in Europe. The Scandinavians also pay their bills. The French are a little bit more skeptical. They don't trust. They don't trust as easily as, for example, the Scandinavians do, that are forced to trade internationally and have always been forced to trade internationally, and realize that if you don't trust somebody, there's no point in doing business with them. And that gets French companies often into trouble with their partners in the United States, because they never really take the time to get to know their partners. And when you don't know your partner and they're 3,000 miles away, you start wondering, what's going on over there in the United States. To me, one of the absolute key issues for a French company to consider when they want to do business in the United States is, do I have the time and do I have the money to do business in the United States? It's really, to me, more a question of time commitment. Are they prepared to make the 4, 5, 6 trips for a week to 10 days each time to keep the pressure on their partners to execute on whatever deal they may have struck?
So it's a big goal or big carrot to dangle in front of you, but you really have to spend a lot of resources.
Absolutely.
Tom Thorelli, founder of Thorelli and Associates law firm in Chicago. Thank you for being with us here at Lunch at the Circle. We'll continue talking more about Thorelli's advice on how to do business internationally over lunch here. Thank you. I'm Per Carlson.